All right, welcome back to the second part of KTN Prime this Wednesday. Thank you so much once more for trusting KTN and sticking with us. We're now heading to a very candid conversation we'll be having with one of the co-sponsors of a very crucial and critical bill, that is the Finance Bill 2025, which was passed by the National Assembly, and we are awaiting the assentment of President William Ruto into becoming law. Remember, we had asked you questions about what you think about this public participation. Do you feel involved in it? Do you feel involved in it? That is just some of the questions that we are going to be sampling, actually, your results from it, or what your thoughts are in terms of this particular conversation. With me, I'm not alone. I am joined by one legal expert, legal mind in the capital. That is already a member of Parliament, Otiende Amolo. Karibu sana.
Thank you.
It's like you went into hiding. We've not been hearing from you for a while. Where have you been?
I am exercising my right to be silent. Well, but I'm glad to be here. It's been a while since I was here, so I'm glad to have this discussion on the public participation bill. Right. We're having this discussion at a very timely place. Remember, we're counting a week shy of from celebrating the anniversary of a very important document in the Kenyan, that is the Kenyan Constitution. It is very timely because on the 27th of August is when we are celebrating the anniversary, and public participation is well envisioned in that particular book. Well, yes, indeed. I was honored to be one of the drafters of the Constitution, and I can confirm that public participation occupies a very central part of the Constitution of Kenya 2010. It is mentioned in very many clauses in the Constitution, and some of it we will discuss. So it is quite timely. It is unfortunate that it has taken us 16 years to come up with a public participation law, but it's better late than never. Yes. But let me ask you, because you've said that or it's well envisioned in the 2010 Constitution, that is public participation, but now you're one of the sponsors of the Public Participation Bill 2025. What different comes with it that is not part of the 2010 in the Constitution? Why the public participation bill? I could say three things. One is because we have not had a legislation to guide what public participation should look like for 16 years, with the result that there are so many pieces of legislation that have been held unconstitutional for want of public participation, because Parliament itself does not know the extent, and other bodies that have made decisions do not know what to do. And the courts have repeatedly said there's need for such a law. Two, it is necessary because I can see that a lot of people complain that their voice does not matter. As we went around getting views of the people on the public participation bill, a lot of Kenyans told us that they are tired of public participation because they give their views, but those views are salutary. They are not given meaning. So they want a law that can define how their views are supposed to be treated, and that's what we seek to do here. And thirdly, there's also exhaustion. Because public participation is not defined, you find that on a single issue, public participation is done even 3 or 4 times. When the policy is being developed, say, by the executive, they do public participation. When it comes to the National Assembly, we do public participation. If it's a law that goes to the Senate, they do public participation in the same places with the same people. And so people also get tired. So this law also seeks to remove, that repetitiveness and the overdose of public participation. So those 3 reasons are among the many for which this bill is important. From what I'm getting from you is that the law tries to sort for meaningful public participation. But when you talk about meaningful public participation, you're also thinking of the threshold. What constitutes a threshold that qualifies a public participation in your end? In this case, I'm going to cite a case that is in court, that is the impeachment of former Deputy President Rigathi Gachagua, and that question of the threshold of the public participation was raised. So how is this new bill going to ensure that that threshold is actualized compared to the 2010 Constitution? Let me answer it in two ways. And first, before I answer it, let me give a little background of the bill. The bill is co-sponsored with my colleague, Honorable Chepkonga, and the bill is a consolidation of various proposals that have been made in the last 16 years, none of which have succeeded. And so we sought to consolidate them with the aid of a bipartisan caucus that we have in the National Assembly, which comprises lawyers and other people, and we consulted the Attorney General. And what the bill does is to establish a framework, okay? It does not go into all the details because public participation is so unique that the way, say, a media house does public participation cannot be the same way a church does it or parliament. That's number one. Number two, what is public participation? Let's start from that meaning. Public participation is defined in this bill as the process of engaging the public in matters, in the making or implementation of any public policy. That is to say, when you are making any decision that affects the public making, then they need to be involved. So in making it, it could be a law being made by parliament or by the county. It could be a decision being made by the executive on taxation, or it could be just on the question of implementation. But the whole idea is that in making it or in implementing it, you must engage the public. Now, the Constitution defines that differently. For example, in Article 1, it says it is the people who are sovereign. They then donate their powers to everyone, the judiciary, executive, parliament. So, parliament or the executive or the judiciary cannot make a decision without consulting the boss, who is the people, because they are sovereign. And that's why when you now come to the rest of the articles, from Article 10, Article 35, Article 118, all the way to 232, there are at least 16 different articles that talk to public participation. So the whole idea then is that you must allow the people to say what they think. But you must not just allow them to say what they think. You must take meaning, give meaning to it. So what is the threshold? What this bill does is to do the following. First, it says any public body that makes a decision or implements the decision must undertake public participation. It does not necessarily extend to private entities because that would be overreaching, but as long as you're a public body. Secondly, in doing that, there are certain features, certain guidelines that you must adhere to, and there are about 10. I can give you a few. First of all, the bill requires that if you are going to do public participation, you must give reasonable notice. People must know that there will be public participation at a given place at a given time.
Let me cut you short, because you've said a very key thing about how this public participation should be conducted. There's a clip I want us to watch.
To start that journey of even anchoring this process into law, as you say, and I want to say that we support, and indeed, Your Excellency, you remember on Monday in our meeting in Naivasha, I did suggest that probably it's time that when we have a national vision like this, we not only anchor it in law, but we also find a way where within the governance structures of our political parties, we ensure that even at a time as this, when we are looking at elections and we're looking at people crafting the election manifestos, that all political parties and elective leaders who are looking for elective positions speak to that greater national vision so that we hold you to account when you get elected as to what you are doing within your manifesto in actualizing that dream, that greater dream of the Kenyan nation. Your Excellency, Senate Majority Leader is telling me that I should say that since we craft laws or we have legislative proposals that we draft into bills and then take those bills back to the people for public participation, what we've actually done today is begun with public participation, and we must look at a way where from this process we then culminate in a a legislative proposal in terms of a bill that will now anchor this process of a national vision into law, so that we obligate all future leaders to the time we are 100 years as a nation and beyond in law, and make sure that nobody ever takes us backward in terms of.
Now, that is National Assembly Majority Leader Kimani Ichung'wah, and that was the launch of Beyond the Vision 2030. I appear to have covered that event. And from what then Ichung'wah says, what was happening there was public participation. You are just from telling us what qualifies as a public participation. Does that qualify?
Yes, it does. In this sense, as I defined public participation, it is engaging the people in making or implementing any public policy decision. Making can come in two ways. Making is the idea of conceptualizing. Like you can sit and decide as a village that we have received 1 million shillings. What is our priority? Some people will say, let's build a school, let's build a dam, let's build a road. That is conceptualizing. Okay? Then making also comes in when you are now making a law that is relevant. In this context, what the majority leader was talking about was conceptualizing, making the decision in terms of what to do and where to go. As I understand it, the president articulated the need for us now to move beyond 2030. Vision 2030 was conceptualized. And at that time, I imagine there was some public participation. It was before the 2010 Constitution, so it was not a constitutional requirement, but there was some limited public participation at that time. It has been implemented throughout, and the requirement is that even throughout the implementation, there should be public participation. As I understand it right now, the president wants to conceptualize 30 years beyond 2030, and is inviting Kenyans to have that conversation of how should it be? What kind of Kenya should we look at? Now, that is public participation at the first level. If Kenyans are to agree on where to go and what to do, and if Kenyans are to agree, as I think the president and the majority leader said, that in their view, in the view of the president, part of the reason why Vision 2030 has not been achieved is because it was not anchored in law. So if Kenyans agree with the ideas around Vision 2060, then the second question would be, should it be anchored into law? And if it is to be anchored into law, that law will be drafted. And when it is drafted, and before it is passed, again there must be public participation. So public participation is an ongoing process that is not limited. It is defined in terms of what you should do. But the more public participation, the better for the citizen.
That takes me back to the question when I asked about the threshold. When we look at that particular event where the president was launching, it was not a law. He was just launching a vision where he expects Kenyans to be in the next couple of years. No law. Let's look at the threshold. Then the number of people that were in that particular event, can that really substantiate into saying that this is where Kenyans want to go?
That, in my view, that by itself is not the end of public participation. In fact, what the president was launching was not the Vision 2060. He was launching the idea of having a Vision 2060. So that Kenyans can have that conversation to buy into it. If they buy into it, then you'll come to the next stage. How should that vision look like? And to understand how that vision look like, you can't just sit in Nairobi and visualize it. You would have to go around the country. When you go around the country, that's when you then take the priority areas and reduce them into a document. If that document then requires a law, you come to the stage 3. You draft that law, and even that law has to be validated by Kenyans. So, for what was happening in Nairobi is not the end of public participation. For me, it is the birth of an idea, and whether Kenyans will buy that idea in itself will require public participation. So let me give you an example. Public participation must be so wide, and I'll come back to the question you asked about impeachment. This bill only, it's a public participation bill. But once we drafted it, it was committed to the Justice and Legal Affairs Committee. The Justice and Legal Affairs Committee, despite the fact that we had consulted a number of people in drafting it, they also had to go around the country. And the committee divided itself into 3 subcommittees of 5 people each. They visited the majority of the counties, at least 24 counties, physically in various places, and interacted with thousands of Kenyans. Some brought written memorandum, making various suggestions. Some spoke, so that the report, which I have here, which is almost 100 pages, captures the views that were packaged from written memoranda running into hundreds to oral submission running into thousands, and all of them are captured to enrich the bill. Because we figured that you cannot do a public participation bill without doing meaningful public participation. I'll come to the question of impeachment of the deputy president, and then I'll come ultimately to the question of how do you define that this is meaningful public participation.
Yes.
There are 2 processes I've been involved in which have been quite widespread. One was the making of the Constitution of Kenya 2010. The committee of experts went virtually everywhere in this country and listened to thousands of views. Ultimately, there were over 1 million views on that document. There is only 260 articles. Views that were similar, views that were dissimilar, views that, and it is the business of the person receiving those views to collate them, rationalize them, see where the majority opinion lies, see where that majority opinion is aligned to the law, and whether to be adopted or not. The impeachment of the deputy president was another process that was done up within a very short time, because the Constitution defines the frame, but very widely. It involved collecting views in all the 290 constituencies and in the 47 counties. And ultimately, as I remember the report, there were over 270,000 views. That's a lot of views. Ordinarily, in public participation, if you get to like about between 5 and 10,000 views, then you have really done quite well. So that was quite widespread, which is why, as I understand it, when that question was raised in the High Court, the High Court found there was sufficient public participation. Whether the Court of Appeal, where the matter now is, will agree or not is a different matter. But let me come back to your original question. If you want to know whether public participation is meaningful or not, the bill identifies 10 different tenets that must be adhered to. 1, you cannot wake up in the morning and give notice that you'll be doing public participation at 10 a.m. The bill requires reasonable notice. And that reasonable notice can be given by putting it in the print media, in the TVs, in the radio, in public gatherings. But the question is, the people whose views you want to receive, do they have notice sufficient to know where it is and to prepare? If you want participation of members of a church, there's no way you can give notice on Monday and then you expect them to come on Wednesday. There must be at least a forum where in church they will have been notified. The second tenet is the question of how the views are given. You must allow people to give views in writing. If they want to give it orally, you allow them. If they cannot give it in writing or orally because they are physically challenged, you must give the provision, including use of sign language. You must allow those who want to give their views online to do so. Thirdly is the question of having a reasonable chance to give the views. You cannot come and you've called people and there are 5,000 and you say we have 10 minutes to take your views. The Act requires that you must give reasonable time. So if there were only 10 people and you gave 30 minutes, that could be reasonable. If there are 1,000 and you give 10 minutes, it is not reasonable. So I can go down the list. Those are just 3. But the point is this. It goes down even to ask, did you allow accessibility for those with disability to that venue? Did you allow a situation where those who cannot understand English or Kiswahili and only understand the local language, did you allow an opportunity for translation so that even those who can only speak Luo can give their views in Luo? So there are 10 tenets that are defined, very well defined in terms of the, what defines meaningful public participation. Okay. Our belief is that when you put this test, then you'll be able to tell there was public participation or there was no public participation. All right.
I'm going to be sampling in a little while some of the comments from Kenyans and what they really think about this particular bill. But a Kenyan out there may wonder, because the problem with Kenya, it is not about the laws. Because, like rightfully said it, public participation is envisioned in the 2010 Constitution. A new law is about to be, once it's enacted, it's going to become a law, the Public Participation Bill. One says they are done with it because that's a process that basically is just to tick boxes. Because members of parliament, they argue they don't listen to some of the views. So how different, a Kenyan out there want to understand, how different is this public participation bill that is going to make them change their mind into thinking that this particular process is just to tick boxes because the Constitution says it, because this other new law says that public participation must take place. So how are they going to garner trust from this particular bill once it's enacted into law?
That's a good comment, and it's a legitimate comment. It has been said many times that Kenya is a forest of laws. We legislate virtually everything. And it's not just about the law, it's even about the Constitution. Our Constitution is easily one of the most progressive in the world, but it's also one of the ones that are relatively long. Why? Because Kenyans have a trust deficit in ourselves, but for good reason. And therefore, even things that can be left to tradition must be legislated. Our Constitution goes into details, including how you must conduct yourself in private, because we believe that if it is not put in a document, then there will be no attempt to follow it completely. So the law may not be the solution, but it is a good start. I observed the last election in the UK. You will be surprised that in terms of provision in law, their law provides less than 5% of what our legislation provides on elections. And yet, in terms of the elections, the challenge is less than 1% of what we challenge here because of trust deficit. So the first response is that statement is correct, that the law in itself is not a solution, but is a good start. Secondly, the law acts as a guide. And as you said, it is a guide because most people don't know what then should be the ambit of public participation. And that's the guide that this bill brings. Just now, as we were waiting to start the interview, I was struck that there were 2 news items about public participation. I saw there was public participation in the nuclear plant to be put in Siaya, where Dr. Buru was commenting. I saw there was a demand for public participation on the tobacco control bill. Even that alone demonstrated the necessity for the law. But the icing on the cake is that once that law is in place, if you fail to follow it, this bill provides that there will be consequences. It's an obligation. If you do not do meaningful public participation, everything that you have done would be nullified by the High Court. So you have a choice to do the right thing as provided by the law, or to waste money and time and then it be nullified and you start again.
But of course, a Kenyan out there may also be wondering, because once you go to court and the process is a bit longer, but the bill or whatever you guys are planning to actualizes. But when it comes to the Public Participation Bill of 2025, who decides whether that participation was meaningful? Is it the Kenyan, or is it the people who are the decision makers? Who decides whether that public participation was actually meaningful?
Initially, in the initial draft, it was suggested that the Attorney General should be the entity that determines compliance with the act, with the bill, that determines whether it was meaningful. Later on, there was a suggestion that it cannot be the Attorney General, because the Attorney General is part of the executive, and a lot of the default in public participation is usually by Parliament or by the executive. So it was suggested that it should be the office of the Ombudsman. But after a lot of discussion and debate and public participation, it was settled that the entity to determine is the High Court. It is the High Court that anyone who says there was no meaningful public participation will go to the High Court. And by the way, it does not take time because the process is shortened. They'll go to the High Court and the High Court will say this was sufficient or insufficient. So the High Court becomes the policeman for purposes of the bill. But let me say one more thing. Although it's taken us 16 years, and although we are on the right path, I would say 50% of the work is done, but it is not complete. Because by its nature, public participation is not just required of Parliament. It is required of the governor, it is required of the county assembly, it's required of the president and the cabinet secretaries, the judiciary, constitutional commissions, state corporations, virtually anyone who deals with public policy. And for that reason, this bill, although it was passed unanimously in the National Assembly, cannot end at the National Assembly. So unfortunately for Kenyans, the president will not be able to assent to it yet. We have forwarded it to the Senate, who must also endorse it for it then to become law.
All right, someone out there may be wondering, why are we talking about public participation when Kenyans are being physically prevented from participating in politics?
Well, that might very well be the very answer to it. Let me explain two things. Strictly speaking, the question of participation in politics is outside the ambit of this bill, because that's already very well catered for. The right to participate in politics, to belong to any party of your choice, the right to move anywhere freely in this country, the right to propagate any ideas, political or otherwise, without hindrance, is well covered in the Bill of Rights in the Constitution. And the Bill of Rights in the Constitution is actually the longest chapter, 40 separate articles. It goes into great detail. But then that right is amplified in various other legislation, so that any hindrance to it would not quite be in the context of this bill. It would be in the context of this bill if there was to be an issue in which of exercise of rights and one was prevented from physically accessing the venue. But that's already very well covered. However, it is always my view that rights are a good thing. And in my view, there can be nothing like over-provision of rights and liberties. The more, the merrier for the citizens. Yes.
But if intimidation, like determines who gets to speak and gags another, haven't we already defeated the urge of public participation?
If it was to be in the context of this act, then that would be a good thing, because it would mean any Kenyan can go to the High Court and challenge that very action or that very prevention. So this then becomes another avenue for the citizens to challenge action or inaction by governmental bodies, where decisions are made without public participation, where laws are passed without public participation, where rights are hindered without public participation, then at least you have a provision of going to the High Court. Without that bill, then that provision will not be there. So other avenues which already exist, and there are many, you can go to the High Court for hindrance of your political rights as it is. You can go to the constitutional commissions, the Human Rights Commission, the Ombudsman. But now this becomes yet another avenue, an additional avenue that gives you direct access to the High Court.
Right. Allow me just to ask then, what is the strongest mechanism in this bill?
The strongest mechanism is that right to go to the High Court.
But it has always been there, even with the Constitution.
No, it has not been there. So far, the courts have complained, and there are no less than 10 cases where the courts urged Parliament to pass some law that defines how public participation is to be done. Because so far, even the judges have not had a parameter against which to measure any action or any legislation. And so this is also part of the reaction to that request, so that the judges themselves, faced with a specific case, can look at the parameters within the bill or the act once it is passed and say, this one satisfies the act, this one does not satisfy. And if it does not, then it nullifies the process, no matter what it is, even if it's an election, even if it's a referendum, or if it's legislation, or whatever action it is. That in itself is the strongest deterrence.
Now, of course, Parliament, the National Assembly did a good thing by passing this particular law, but Kenyans out there may ask, why should they trust Parliament to, enforce meaningful public participation, yet they are accused of not listening to Kenyans' opinion in various bills, for example, just a case in point of the finance bill?
That is the whole point, that Kenyans don't have to trust Parliament with its enforcement. That's why the enforcement is not with Parliament, it's with the High Court. Parliament is one of the entities that are obligated to do public participation.
And that is where I'm coming in, when I say that, yes, Kenyans feel like this is just an exercise to them. Like it's not as meaningful as it ought to be. That's what they're saying, because Parliament is one which is obligated into ensuring that public participation has been conducted, like meaningful public participation has been conducted. But Kenyans are throwing an accusing finger to the same Parliament, saying that our opinions or our opinions are not, taken into consideration.
Let me explain it differently. Part of the reason we are having this bill is that complaint. In so many places, people told us that Parliament, among others, come for public participation as a salutary gesture, just so that we can tick the box and say, we did public participation in Kibra. Kenyans say, we want meaningful public participation, okay? So the reason for having this bill is to answer that concern. Without the bill, the concern remains. This bill goes further to require that when you do public participation, other than giving people an opportunity to express themselves, you must then do a report. That report must analyze and capture the views that were given. And as it captures, it is expected, as it is usually done in our reports, that you must indicate of those who gave their views, say 70%, as we did, for example, with the Constitution. At that time, 51% of Kenyans wanted a parliamentary system. 49% wanted a presidential system. If you adopt a presidential system like we did, then that report must explain why. Why did we ignore the majority? That's the first point. The second point is that it removes the decision from Parliament to the judiciary, so that Parliament, being one of the primary culprits, should not be the one making the decision. Let the High Court make the decision whether Parliament complied or not. That is why this bill becomes meaningful. It removes the discretion from Parliament to an objective standard and then to the court.
And I think that is why I was asking then, how different is it from the 2010 Constitution? Because Parliament has always gone to conduct this public participation and having the views brought into Parliament, all that. So how is that process different from your bill that you have sponsored in Parliament?
The Constitution doesn't give details. The Constitution says there must be public participation, and it says that in various articles. The question that has been asked for the last 16 years, and you've asked it about 5 times, is how should that public participation be done? This bill is not different from the Constitution. But this bill now gives meat to what the Constitution suggests, public participation in 2 words. So this bill now comes in to define what it entails. And the reason we even collected views on it is to ask Kenyans, and we asked them, do you think now this bill satisfies what your understanding of public participation is? And in many places, they added a lot of things that I was telling you about, that unless you have this mechanism, in fact, some said that we want that once public participation is done, you must come back to everyone who spoke and explain to them why you did not take their view. Now, that is not practicable. So instead, what the bill does is to say the report must capture the views, and if the views are not adopted, explain why. So that's why it's giving effect to the Constitution.
All right, you're going to allow me just to cross over to this other side and get to understand what Kenyans are saying in regards to the big queue that we had asked today. So we had asked, what does public participation mean to you? And we had given them some answers. We had my right to be heard. We have 40%, which is tying with just a formality. I don't understand it. It seems like most of the people understand that particular bill. And others say that public participation means holding leaders accountable. Now, when we have a good number saying that it is their right to be heard and just a formality, I think that is something that is good when it comes to your bill. We had also asked, let me just get the other one. We had also asked what does public participation mean to them in regards to this particular conversation. The highest numbers are saying my right to be heard. Okay, this is the same. Let me just ask. This is the other one. We had asked, do you feel your voice really matters when you participate? And this was a question that I was really pressing on because Kenyans really wonder a lot whether their voices are heard in terms of their views. The highest number says no. Ignored. And this is what I was raised when I said that most Kenyans are saying, why do we need to have this bill, yet our voices is just like a tick box for our views. So perhaps let us first look at this number. 77.1% says their views are ignored when they participate. Your bill, right? You've said that perhaps if you can talk to this 77.1% and tell them why they shouldn't feel this way when this new bill, once it passes Parliament and enacted into law, they're really not going to understand why their voices matter.
Actually, I think the response from Kenyans vindicate the very reason for having this bill. And it mirrors what we had as we went around the country on the bill. Because many Kenyans get frustrated and they say their views are not factored in. The reason why we are having this bill is to make sure that the views of Kenyans are factored, as a matter of fact. That is why the bill goes further and says, you don't just go and listen and tick a box and you go back and continue. You must then prepare a report that analyzes the views. That report must be publicized, as in it must be a public document that anyone who participated can access. If you participated by way of public participation on anything and you feel your view was ignored, then you can challenge it. You mentioned the question of the Finance Bill 2024, for example. If this bill was law then it would be a question of demanding of Parliament, where is the report of public participation across the country to see what Kenyans said? How does the bill that you have now presented reflect the views of the Kenyans? And if you come to the conclusion that it does not, then you may not even need to go to the street. You would go to court and have the entire bill declared void for the reason for not complying with the law. So this bill seeks to answer that concern by Kenyans, and 77% of them are concerned, so that their views will no longer be ignored. So actually the views, the response to your question reflects the very reason why why we need a law that defines public participation.
All right, let us talk about, you had said that through the bill, the Kenyans will have the right to go to court once they feel that the public participation was not met. What burden of proof will the citizen have in order to prove to the court that that particular public participation was a sham?
The bill makes it easier. For now, so far, if you go to court to challenge anything, whether it's law or any decision for insufficient public participation, it is usually said in law that he who alleges proves. Yeah. So the burden of proving insufficient public participation is on you. But with this law, that burden is removed from you and placed on the parliament or any other authority that was doing it. How? Because the law outlines, as I told you, the guidelines that you must adhere to. So it is you, not the Kenyan, who will have to prove. So first, you will have to show that that notice was reasonable. As I told you, there must be reasonable notice. You must show that you gave them sufficient time to advance the views. You must show that you enabled them to access the place of public participation. You must show that you allowed them to express themselves in a language that they understood, whether it's a local language, whether it's sign language, or anything else. You must show that you factored in their views and analyzed it. You must show that you published the outcome. So the burden is removed from the Kenyan. Right now, it is on the Kenyan who goes to court. With this law, the burden is on the public entity. If it is Parliament that will show that all those 10 guidelines were met, and therefore it becomes easier.
All right, let us talk about the 21-day period that is supposed to, has been, as per the bill. The ultimatum is a 21-day period of public participation. What legal justification is it for these 21 days?
Actually, there was a proposal to have a number of days, but that was removed. So there's no 21 days. What the bill says is reasonable notice, okay? And we have used the word reasonable because in law, that word reasonable is usually well understood. You cannot have a fixed timeline. Why? Because different things require different timelines. There could be an earthquake. You need some very urgent action. You need some urgent consultation. You only have hours. You can't be told to wait for 21 days. Or you could be wanting to change the constitution. 21 days is not sufficient. You need more time to consult Kenyans. So what the bill says is the time must be reasonable relative to what action is it you want to take or what law is it you want to change. And therefore, you must be able to demonstrate that given the circumstances, take the one of the Deputy President, for example, because the National Assembly had less than 10 days by law to process it. And therefore, the public participation was done in all the constituencies well within 7 days. So the question is, if the law gives the National Assembly a maximum, say, of 10 days, could it be reasonable to expect them to extend it beyond 10 days? The answer is no. So it could be reasonable. But if it was a question of a referendum, would you expect Kenyans to look at a referendum for a new constitution within 7 days and give a verdict? The answer would be no. So it's a question of the reasonableness of the circumstances.
All right, the 500,000 penalty was also struck when the bill was on the floor of the House. So if there is no penalty of people who actually go against that law once it gets into law, so what will come out of it if there's no penalty at all and people, you can either public participate or not because there's no that penalty that binds them? Let
me explain. For us as the sponsors of the bill, we had proposed a penalty.
Yes.
Because we thought two things. One, we thought that when you place an obligation on public participation, say on the standard group, it should lie on the shoulders of an individual, so that if they don't do it, you know who to come for, okay, or not. And in that context, if there's failure, then you can take that individual and charge them and fine them. The contrary view in Parliament was that you might be placing the responsibility on a wrong shoulder. For example, in Parliament, their proposal then was to place it on the shoulders of the clerk of Parliament. And then the argument came that the clerk is not even a member of Parliament. So when you say Parliament has defaulted, and then you penalize the clerk, and the clerk has no say in Parliament, then you're going for the wrong person. In fact, you would be encouraging Parliament to default, yes, because they know there'll be no responsibility on them. So in that context, it was thought that to enforce it better, if you say National Assembly, make it National Assembly and all its members, then they feel a sense of obligation to go with it. But once you do that, then you cannot have a criminal provision, because how do you now take all 400 and over 400 members of Parliament and charge them with a criminal offense? You know, it becomes impossible. So the debate in Parliament was remove the idea of one person, place it on the institution. But where there's a defined accounting officer, like a governor in the county, then it lies on the governor. Yes? But once you do that, then you cannot still have the criminal provisions. So instead, make it higher. The threat that you will nullify everything that Parliament has done, or the County Assembly has done, or the executive has done, is higher than fining them. Because otherwise, people might find it easier to default and pay the 500,000.
Yes.
But if they know it will be, you know, voided, it will be nullified by the court, then they are more likely to comply. And that's why it was changed. So it's a question of principle. It's not necessarily that it was watered down. It was thought that the idea of nullifying it by the court is a greater deterrence than one defaulting and paying a fine and defaulting and continuing to pay that fine, because some of those defaults, paying a fine of 500,000 is nothing, and many of them might pay it using the taxpayers' money anyway. So it was a question of change of principle.
All right. Our time is almost winding up, but of course we cannot conclude this conversation without having a tete-a-tete about what is happening in the country. As much as we are talking about that freedom of expression in terms of public participation, the country at large, what is happening at the moment? Perhaps, what can you speak of it in terms of we are seeing increasing Goonism and tension as we head to 2027?
Well, there's so much happening in the country.
Yes.
But I'll say two things. First, the concept of Goonism and the way it's rising is extremely dangerous to this country. It is more dangerous than what I saw in 2007. What happened in 2007 that almost brought this country to collapse was spontaneous. The Goonism that is being cultivated is not spontaneous. It is being nurtured. It is being grown. And it will get to a stage where it will outgrow even those who are nurturing it. It does not matter which side of the political divide you are in. When it gets to that stage, we will not have a country. It is extremely important that it is nipped at this stage. It is important that we see some really clear and drastic action to stop the Goonism that is taking root. Because if it continues this way, first of all, it will not be possible for anyone to campaign, not just nationally, but even within the counties, even within the constituencies. Because what is being shown up here will be translated to the village. Secondly, it is important that our accountability institutions wake up and exercise all the powers that they can, to the extent that they can. I have always been of the view, and I did this when I was the ombudsman, to take the view that you should not inhibit your powers. Exercise all the powers as long as they are not expressly inhibited, and let somebody challenge whether you have the powers to do that. And therefore, the accountability institution, the police, everyone should go full throttle. Thirdly and lastly, as a human rights lawyer for the last over 3 decades, as one who drafted the Constitution, and as one who belongs to the Orange Democratic Movement Party, democracy plays a very fundamental role in our DNA. Any person, any political grouping must be allowed to go anywhere in this country without being allowed by permission that now we permitted you to come, or without being stopped. And that should be including not just by physical violence, but even by violence in words. Let the people hear everyone who wants to come, and let the people make a decision who they want to stick with. Because ultimately, votes must be gotten by persuasion, not by force.
All right. When we have the Interior Cabinet Secretary saying that it is politicians who, are financing these particular goons, President William Ruto has said enough is enough. Do you think maybe the government is unable to actually control or tame this Goonism as we head to 2027? And should Kenyans be worried?
Without ascribing any responsibility to anyone, whether it's politicians or not, the point is, whoever causes them, whoever causes it, whether it is the church, whether it's night runners, whether it's musicians, whoever it is, if our accountability bodies can do their work, then we will not be having that debate. Let the work that is done demonstrate who is causing it. But let's not have rhetoric in terms of who's causing, but no action is taken. Even if it's politician, it is the actions that are taken against some politicians that will stop the rest of politicians from undertaking that kind of thing. But that can only be done by the responsible authorities. Yes.
Perhaps maybe do you have some pointers for them to take, because it seems, because the Goonism did not start with Homa Bay. It started way back. And it is a trend that is even worsening by day when you compare to how it started. Perhaps what are these measures that maybe that could be...
The law, the Constitution is clear, the law is clear, and you started by saying that we do not suffer from insufficiency of laws, and it is true. Goonism is a concept, but everything that a goon does is clearly criminal. And I can define to you more than 20 different clauses in our criminal legislation that any ordinary goon would be charged under. So it's not a question of the law. It is a question, as I said, of the responsible authorities doing their work, from the investigative agencies, from the intelligence agencies, from the prosecution agencies, from all the other agencies doing their work. This country, you cannot even drive 1 kilometer without some intelligence being gathered around you. So I am sure that if we put our foot down and if the responsible authorities decided to do their work in terms of intelligence gathering, in terms of prevention, in terms of investigation, in terms of prosecution, in terms of sentencing, we would nip this in the bud. But there must be a clear commitment for the responsible authorities to do their work. As long as they don't, we will keep having this debate. We will even start saying the goons are being sponsored from abroad, as we used to say during Moi days, people are coming from abroad to do all these things, but they are not. It is all within us. The responsible authorities must just do their work.
All right. This is a conversation that I know cannot take a day or two, because like I said, the Goonism did not start with Homa Bay. It started from way back. It has been going on and on and on, and it's just a matter of when, if not if, the president is going to act on it. And that it will be facing the basis of the Bold newspaper tomorrow morning. What are you waking up to? For how long, Mr. President? You know, ICC goes in what appears to be frustration among Kenyans over the government's lack of will to tackle the goons menace and the descent into lawlessness perpetrated by political leaders. The International Criminal Court demanding scrutiny of the escalating violence and possible accountability for those responsible. The opposition says the ultimate backstops with the president, whose government has a duty to protect Kenyans and uphold the rule of law. That story, the front page of the Bold newspaper, The Standard. Make sure you grab yourself a copy. For how long, Mr. President, are we going to be getting these goons that are infiltrating innocent Kenyans? You know, they're causing mayhem to our country. Remember, it's just a year shy of to 2027. Mr. President, something needs to be done about this Goonism. It does not matter which the politicians, whether they are financing them or not, something needs to happen, and that backstops with you, Mr. President. Well, and that is where we wrap up this edition of KTN Prime this Wednesday. Once more, Tiende, thank you so much for coming through and breaking the one-year silence and cycle here at KTN. Asante sana. We'll be getting you soon, I know.
Thank you.
Once more, thank you so much for your company. My name is Grace Nganga. Lois was our sign language interpreter. Do have yourselves a lovely night.